All right, so why should I give him 5 years? The complainant in this case is the same complainant that he has the new case on.
There was some other things going on in his home life and stuff. I believe he's had some family health issues and stuff.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years. All right, the court is going to sentence you.
This dude walked into court acting like 5 years was some kind of fair trade for what he did. Like this was supposed to be the end of the story. What he conveniently left out is that this wasn't even his only assault case. He's got a second assault charge involving the exact same victim. And somehow, he thinks both cases should just roll together, like a buy one, get one deal in a criminal courtroom. As soon as Judge Boyd starts digging into the details, you can feel the energy shift, because this isn't just a bad day situation. This is a pattern. I genuinely don't understand how someone can nearly take out the person they claim to love, twice, and still walk into court with this level of confidence. Let me know in the comments if you think 5 years is ever enough for repeat violence, or if this guy deserves the absolute max. Let's dive in.
Calling 2025 CR 01152. Could I have parties announce?
Your Honor, there's also the MTR.
Yeah, I'm going to take this up first.
Can we do the MTR first?
Why are we doing the MTR first? And are you Mr. Geary?
Yes, ma'am.
Counsel, you received all discovery?
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. By entering into a plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived indictment, freedom of information, and rights under Article 1.051. By information, you're charged with assault family household member with a previous conviction. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. According to the plea, punishment is to be assessed at 5 years in the prison. There's a $1,500 fine. Did you understand that to be the plea?
Yes, ma'am.
State?
There is, with the exception of, I had put restitution, should there be any, I know that he would be entitled to restitution here.
All right, it's going to be restitution, if any. Let me just tell you, if they're sending you to prison and your counsel is waiving a PSI, then whatever that restitution amount that person claims, that's going to be the restitution amount. And when you're up for parole, they'll take it up with parole. Do you understand?
Yes, ma'am.
All right, restitution, if any, to Anessa Nicole Guerra. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. At this time, state orders into evidence, states Exhibit 1 with all attachments.
No objection, Your Honor.
Court will accept into evidence states Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, it was kind of a tough decision for Mr. Geary to come to, but he thinks it's in his best interest, and he would ask the court to go along with the plea bargain that it's taken us quite some time to negotiate. But I think he wants to get this behind him. It's unfortunate that we've ended up here, but I think he is ready to move on and become a protective citizen once he gets this behind him.
All right, the court is going to sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Anessa Nicole Guerra. There's a $1,500 fine. State is taking in consideration 2025 AL 006681, 2025 PF 31338, and this will run concurrent with 2020 CR 12202. And there's to be no unsupervised contact with minors. Is there anything else with regards to sentencing?
No, Your Honor.
Just whenever we're finished with this and the MTR, we have the victim present who wishes to do victim impact statement.
Okay. All right, we're proceeding with 2020 CR 12202. Are you the same Juan Carlos Aguirre Jr., who was placed on deferred adjudication in 2020 CR 12202 for the offense of assault, family choking, strangulation on March 3rd, 2021, for a period of 3 years. Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor, violation of condition number 15. On or about the 12th day of May 2021 in Bexar County, Texas, the defendant, Juan Carlos Aguirre Jr., did then and there fail to attend, comply with all rules, regulations, instructions, and financial agreements as directed by the court and or supervision officer and or the head of or authorized personnel of the following counseling education program, state accredited battering intervention and prevention program, in violation of condition number 15.
How do you plead to that? True or not true?
True.
This part honestly blows my mind. We're talking about a second assault on the same victim, and somehow the discussion turns into whether the next 5 years should just run at the same time as the first. That makes zero sense to me. If you're already on probation for putting someone in a hospital, and then you go right back and do it again, why would that ever be treated like one big case? This is exactly the kind of situation where the system is supposed to drop the hammer, because it proves the first sentence didn't teach anything. And honestly, this is the type of defendant who makes real victims feel hopeless. He already had every chance to get his life together and still chose to go right back to the same violence. If there's ever a moment where consecutive time actually makes sense, it's something like this. Do you guys think concurrent time like this makes any sense for repeat violence?
State will waive the remaining violations, Your Honor.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 15, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition 15?
Yes, ma'am.
Court will find violation of condition 15 true. Is there a proposed agreement?
There is, Your Honor. That is to revoke the defendant's probation, adjudicate him guilty, and sentence him to 5 years TDC.
All right, so why should I give him 5 years? Because the complainant in this case is the same complainant that he has the new case on. And so why should I do this?
Judge, if we're speaking about this probation, this deferred adjudication, Mr. Geary was doing the things he was supposed to be doing at the time. He was enrolled in BIP. In fact, if you look at the records, I believe he did all but 4 classes of the BIP. But because of other circumstances, the MTR was filed on him, and he did not complete it. There was some other things going on in his home life and stuff. I believe he had some family health issues and stuff, but he was doing the things he was supposed to be doing. He just didn't complete it because of the circumstances. So that makes him not a good candidate for probation. But I don't think to punish him in excess for something that's occurred after this probation expired is fundamentally fair on the original deferred.
No, I mean, because he hasn't learned anything. And I don't know what's happening in his relationships, but it doesn't appear he's learned anything. And I don't know why I should sentence him to just 5 years when he's been sentenced on an assault family household member with a previous conviction, which means there's a previous conviction, and it's against the same complainant that he's on probation for. State, why should I give him 5 years?
It just seemed that in your best interest, considering, yes, it's the same victim, but for efficiency and judicial purposes for both cases to run concurrently together.
All right, this is what the court is going to do. The court is finding 15 true. The court is going to grant the motion, find you guilty, revoke, sentence you to a $1,000 fine, time and money run concurrent. There's an affirmative finding of family violence. This will run concurrent with 2025 CR 011524. There should be no contact with Anissa Guerra. There should be no residing in a household with minors. There should be no unsupervised contact with minors, and the court is going to sentence you to 8 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, for the most
You
part.
do have a limited right to appeal. That right to appeal is that as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence and a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're going to have to start making better decisions. Otherwise, you're going to find yourself in and out of somebody's prison. You understand?
Yes, ma'am.
And your relationship with her is over.
Oh,
You
yes,
understand?
ma'am.
All right, good luck to you.
I don't know about you guys, but 8 years honestly feels light when you really think about what this man put someone through twice. That said, seeing Judge Boyd go above the plea deal at least shows the court wasn't willing to treat this like a one-time mistake. It's a reminder that when violence becomes a habit, the justice system eventually stops giving you soft landings. On a real note, though, I just hope the victim finally gets distance and peace after all of this, because nobody deserves to live in fear, especially as someone who keeps proving they can't control themselves. And I know 3 extra years might not sound like much to some people in the comments, but that is a long time when you're sitting in a cell thinking about your choices. Considering the maximum here was 10 years, let me know what you think. Was 8 enough, or should the judge have maxed him out? Thanks so much for watching. Guys, make sure to like and subscribe as always. Every comment and bit of feedback really helps me make better videos, and I truly appreciate it.